Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST, and more. Get certified to enhance employability.
There are 4 opinions in the case. I have authored the majority opinion for Justice Sanjeev Khanna, Justice Jamshed Padiwala, Justice Manoj Mishra, and myself. There are 3 dissents. Justice Suryakant has written a separate opinion. Justice Dipankar Datta has written a separate opinion. Justice Satish Chandra Sharma. They have each authored their own opinions. So it's 4-3. I'll read out just a few pages. The petitioner and the respondents disagree on whether this bench must determine if AMU is a minority educational institution. In Anjuman-e-Rahmaniya, the 2-judge bench referred the question of the essential ingredients of a minority education institution. This was the core issue which was referred to the Constitution bench. The other 2 questions which were formulated, that is the meaning of the phrase established and the impact of registration under the Societies Registration Act 1860 after the establishment of the institution, are in a sense subsets of the core issue. The question of the indicia for recognizing an educational institution as a minority educational institution was reflected in question 3A framed in TMA Pi. Thus, neither was Anjuman-e-Rahmaniya nor TMA Pi concerned with the factual situation in Azeez Basha, that is whether AMU is a minority education institution. The 2019 reference order also limits the reference to the legal aspects arising from the decision in Azeez Basha and not the factual aspects of the decision relating to AMU. This is clear from the passages from the 2019 reference order extracted above, particularly paragraphs 8 and 9. Paragraph 8 states that the correctness of the question arising from Azeez Basha has remained undetermined. The paragraph indicates that the 2019 reference order must be read along with the previous references in both Anjuman and TMA Pi Foundation. Paragraph 9 mentions that the correctness of the views in Azeez Basha, which has been extracted above, requires an authoritative pronouncement. The paragraph from Azeez Basha extracted in the 2019 reference order deals with the question of the indicia to be considered a minority education institution. It is thus evident upon a reading of the reference orders that the question of the criteria to be fulfilled to qualify as a minority educational institution is referred to this bench. From the order in Anjuman-e-Rahmaniya, referring the judgment in Azeez Basha to a larger bench, the question formulated in TMA Pi and the 2019 reference order, the question that must be decided by this bench is what are the ingredients, indicia, or criteria for an educational institution to be considered as a minority educational institution under Article 30. The following issues must be answered for this purpose. A. Whether an educational institution must be both established and administered by a linguistic or religious minority to secure the guarantee under Article 30. B. What are the criteria to be satisfied for the establishment of a minority institution? Whether Article 30(1) envisages an institution which is established by a minority with participation from members of other communities. C. Whether a minority education institution which is registered as a society under the Societies Registration Act 1860 soon after its establishment loses its status as a minority education institution by virtue of such registration. And D. Whether the decision of this court in Professor Yashpal versus State of Chhattisgarh and the amendment of the National Commission for Minority Educational Institutions Act 2005 in 2010 have a bearing on the question formulated above, and if so, in what manner? Doubting the correctness of the opinion in Azeez Basha, without disagreeing with it, the 2-judge bench in Anjuman-e-Rahmaniya requested that the matter may be placed before the Chief Justice of India for being heard by a bench of 7 judges. This falls within the permissible limits laid down in Central Board of Dawoodi Bohra Community, as explained in point B of paragraph 37. Further, the learned Solicitor General has also stated that he is not pressing the union's preliminary objection. The order of reference dated 12 February 2019 too noted that although a 3-judge bench could not ordinarily refer a case directly to a 7-judge bench, it was doing so in this case because the question has already been referred to a bench of 7 judges but was not answered. It cannot be disputed that Article 30 guarantees the minority education institutions the right to not be discriminated. In fact, Article 32 is a facet of the principle of non-discrimination of minorities. The article provides that the state shall not discriminate in granting aid to educational institutions or discriminate on the ground that it is under the management of a religious or linguistic minority. The question is whether the use of right in Article 30(1) also guarantees a special right in addition to the right to non-discrimination. Until the judgment of the 11-judge bench in TMA Pi, the right to establish and administer educational institutions was interpreted as a right that was exclusively available to religious and linguistic minorities by virtue of Article 30. In TMA Pi, the right of every citizen to establish and administer educational institutions was traced to Article 19(1)(g), which guarantees the freedom to practice any profession or to carry on any occupation, trade, or business. The 11-judge bench also traced the right of every religious denomination of both the majority and the minority to establish and administer educational institutions to Article 26A, which guarantees the right to establish and maintain institutions for religious and charitable purposes. Charitable purposes were interpreted to include education. The rights guaranteed by Articles 19(1)(g) and 26A can be reasonably restricted on the grounds in Articles 19(6) and 26 respectively. An educational institution established and administered by any citizen can be regulated on the grounds stipulated in Article 19(6), which includes the ground of professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade, or business. An educational institution established by a religious denomination without any element of profit can be regulated on grounds of public order, morality, and health. As opposed to these two provisions, Article 30 does not circumscribe the right on any grounds. This court has, however, consistently emphasized that the right guaranteed by Article 30 is not absolute. In State of Kerala versus Reverend Mother Provincial, the six-judge bench differentiated between restrictions on the autonomy of a minority institution and the standard of education. The former is impermissible in view of the protection under Article 31. The latter was traced to the regulation of the profession, which is covered by Article 19(6). Thus, regulation of a minority educational institution is permissible on the grounds in Article 19(6). However, the regulation must not infringe the minority character of the educational institution. Article 31 is absolute in that sense. Regulations that may be justified on the grounds stipulated in Article 19(6) and 26 may fall foul of Article 30 if they infringe the minority character of the institution. This is the special right or protection which the Constitution guarantees minority education institutions. This special right is a guarantee of limited state regulation in the administration of the institution. The state must grant the minority institution sufficient autonomy to enable it to protect the essentials of its minority character. The regulation of the state must be relevant to the purpose of granting recognition or aid, as the case may be. This special or additional protection is guaranteed to ensure the protection of the cultural fabric of religious and linguistic minorities. This court in Azeez Basha held that the words establish and administer must be read conjunctively. That is, the guarantee of the right to administration is contingent on the establishment of the institution by religious or linguistic minorities. The question is whether the conjunctive reading of the words establish and administer would also mean that for an educational institution to be a minority institution, it should have been both established and administered by a minority. In Azeez Basha, the Constitution bench held that the institution must be both established and administered by the minority. Article 31 cannot extend to a situation where the minority community which establishes an educational institution has no intention to administer it. A religious or linguistic community may establish an educational institution and yet not administer it. This is evident from Article 28(2), which states that Article 28(1) will not apply to an educational institution which is administered by the state, but was established under an endowment or a trust which require religious instruction to be imparted. It is quite possible that a member or a group belonging to the minority community wishes to establish an institution, but intends to accept greater state regulation and lesser autonomy for the community. In that sense, putting a minority tag on such an educational institution merely because it has been established by a person or group belonging to a religious or linguistic minority would not be permissible under Article 31. An educational institution established by a minority, whether linguistic or religious, can give up their right to claim the benefit of Clause 1 of Article 30. The right can be given up consciously by waiver. This may occur where administration has been consciously and willingly entrusted to the state. Therefore, to determine whether an educational institution is a minority educational institution, a formalistic test such as whether it was established by a person or group belonging to a religious or linguistic minority is not sufficient. The test adopted must elucidate the purpose and intent of establishing an educational institution for the minority. Both the establishment and the administration by the minority must be fulfilled cumulatively for that. A distinction between educational institutions established before and after the commencement of the Constitution cannot be made for the purposes of Article 31. Article 30.
Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST, and more. Get certified to enhance employability.
Article 30 will stand diluted and weakened if it is only to apply prospectively to institutions established after the commencement of the Constitution. What is the scope of Article 30 when read in the context of Article 372 read with Article 13? Any law enacted by the imperial legislature which discriminates against linguistic and religious minorities in the establishment and administration of educational institutions would be void. This is the scope of the provision vis-à-vis Articles 372 and 13, when Article 30 is purely read as a negative right. But this court has also interpreted the article as a special rights provision, guaranteeing additional protection to educational institutions established by minorities. Thus, educational institutions established by religious and linguistic minorities before the commencement of the Constitution will also receive the special protection guaranteed by Article 30, the right to administration without the infringement of their minority character. Could it be argued that a university was established by the legislature merely because it enacted a legislation incorporating it? The words incorporation and establishment cannot be used interchangeably. They connote different things. Incorporation signifies the legal existence of the institution. In contrast, establishment signifies the founding or bringing into existence of the institution. The possibility of distinguishing the establishment and incorporation of universities arose with the advent of teaching universities. Two kinds of institutions were incorporated as teaching universities. They consisted of institutions which were established and incorporated at the same time, and institutions in which the establishment of the institution predated its incorporation. Universities in the latter category, however, were teaching colleges converted into teaching universities. The establishment and incorporation of these universities was distinct. The instance of conversion of teaching colleges to teaching universities elucidates the distinction between the establishment and incorporation of educational institutions. The word establish, as used in Article 31, cannot and should not be understood in a narrow and legalistic sense. The words used in Clause 1 of Article 30 have to be interpreted in view of the object and purpose of the article and the guarantee and protection it confers. It cannot be argued that a university was established by Parliament merely because the long title and preamble of the statute incorporating the university states that it is an act to establish and incorporate. If such a formalistic interpretation is adopted, fundamental rights will be made subservient to legislative language. The courts must identify the circumstances surrounding the incorporation of the university, including a thorough reading of the statute, including through a reading of the statute, to identify who established the university. Formalism must give way to actuality and to what is real. The right under Article 31 is guaranteed to minorities as defined upon the commencement of the Constitution. A different right-bearing group cannot be identified for institutions established before the adoption of the Constitution. To determine who established the Constitution, the courts must consider the genesis of the educational institution. For this analysis, the courts must trace the origin of the idea for the establishment of the institution. The court must identify who was the brain behind the establishment of the educational institution. Letters, correspondence with other members of the community, or with government or state officials, and resolutions issued could be valid proof for establishing ideation or the impetus to found and establish. The proof of ideation must point towards one member of the minority or a group from the community. The second indicia is the purpose for which the educational institution was established. Though it is not necessary that the educational institution must have been established only for the benefit of a religious or linguistic minority community, it must predominantly be for its benefit. It is not necessary that education must be provided in the language spoken by the minority or in the religion of the minority. The indicia could be proved by a reference to private communications or speeches about the necessity of establishing an educational institution for the community and a recognition of the educational difficulties faced by that community. The third test is tracing the steps taken towards the implementation of the idea. Information on who contributed the funds for its creation, who was responsible for obtaining the land, and whether the land was donated by a member of the minority community or purchased from funds raised by the minority community for this purpose, or donated by a person from some other community, specifically for the establishment of a minority educational institution, are elements that must be considered. Similar questions must be asked of its assets. The next question is whether the administrative structure of the educational institution is an indicia for the establishment of a minority educational institution. We have already held above that an educational institution is a minority educational institution if it is established by a religious or linguistic minority. We have clarified that it is not necessary to prove that administration vests with the minority to prove that it is a minority educational institution, because the very purpose of Article 31 is to grant special rights on administration as a consequence of establishment. To do otherwise would amount to converting the consequence to a precondition. The right to administer is guaranteed to minority educational institutions to enable them to possess sufficient autonomy to model the educational institution according to the educational values that the community wishes to emphasize. It is not necessary that the purpose can only be implemented if persons belonging to the community helm the administrative affairs. This is so particularly because a minority institution may wish to emphasize secular education. The test to be adopted by the court is whether the administrative setup of the educational institution affirms the minority character of the institution. If the administrative structure of the educational institution does not reflect its minority character, or when it does not elucidate that the educational institution was established to protect and promote the interests of the minority, it may, however, be reasonably inferred that the purpose was not to establish an educational institution for the benefit of the minority community. We may specifically deal with a scenario of an educational institution established before the commencement of the Constitution. The test of administration should be evaluated in presenti, that is, on the date of the commencement of the Constitution. An institution to be a minority institution must satisfy the criteria of being administered as a minority institution on the date of the commencement of the Constitution and being a minority institution on the date of formation. Even if an educational institution was established by the minority for the purpose of the community, we must assess the impact of any subsequent events that alter the character of the institution before the commencement of the Constitution. The court may, on a holistic reading of the statutory provisions relating to the administrative setup of the educational institution, deduce if the minority character of the purpose of establishment was relinquished upon incorporation. The question is whether the regulatory measures wrest the administrative control from the founders of the institution. This is a question of fact which must be determined on the facts of each case. The court must make that determination upon a comprehensive analysis of the administrative framework, which includes a host of factors such as the representation of the interests of the community in the administrative setup. The above indicia must be proved through the submission of cogent material. Reliance must be placed on primary sources such as office documents, letters and resolutions, or memorandums issued to implement the resolution. Secondary sources must be only used to corroborate the primary sources. The onus to prove that the educational institution was established by a minority is on the claimants. The view taken in Azeez Basha that an educational institution is not established by a minority if it derives its legal character through a statute is overruled. The question of whether AMU is a minority educational institution must be decided based on the principles laid down in this judgment. The papers of this batch of cases shall be placed before the regular bench for deciding whether AMU is a minority educational institution and for the adjudication of the appeal from the decision of the Allahabad High Court in Malay Shukla's case after receiving instructions from the Chief Justice on the administrative side.
In my opinion, I have said that a three-judge bench presided by the then Chief Justice of India, by order dated 12 February 2019, passed in Aligarh Muslim University versus Naresh Agarwal, made this reference to a bench of 7 judges with a view to determine the correctness of the question arising from the decision of this court on Azeez Basha, which had ruled against the minority status so to be accorded to AMU. Second, to determine question 3A formulated in TMA 5. And third, whether the decision of this court in Professor Yaspal versus Chhattisgarh State of Chhattisgarh and the amendment in 2010 in National Commission for Minority Education Institute Act 2004 have any bearing on the aforesaid question formulated. The fulcrum of this reference rolls around the interpretation of Article 30 of the Constitution of India, which deals with the right of minorities to set up education institutions. We have had the benefit of perusing the erudite majority opinion authored by Honorable the Chief Justice Dr. DY Chandrachud. While the said opinion comprehensively addresses each issue with depth and clarity, we have expressed a differing view on the interpretation of certain aspects given the significant constitutional implications involved. Recognizing the weight of these issues, we have chosen to offer our own perspective, though we acknowledge the thoroughness and diligence